Sure.
Just 30 seconds.
There you are.
Hello. Sorry, I couldn't get the thing to come on.
No worries. Tony and his guy are in a breakout room. Yeah. All right.
We are good to go, Judge.
We are good to go. All right. Let's go ahead and be on the record in case number 2019 CR 957, captioned State of Kansas versus Caleb Shaffer. Would the parties announce their appearances, please?
May it please the court, the state of Kansas appears through Assistant District Attorney Adam Sokoloff.
And please the court, defendant appears by Zoom with video with counsel Anthony Russo, also by Zoom.
All right. We are here set down for a sentencing. The parties were in court back on June 4th of last year, at which time the defendant changed his plea from one of not guilty to guilty. The court inquired and accepted that, ordered a pre-sentence investigation, set it for sentencing. We've had a number of sentencing hearings, continued for one reason or another, and now we are ready today for that sentencing. I have received and reviewed the pre-sentence investigation. The critical findings are as follows. The sole count of conviction is one of theft of a firearm. That's a severity level 9 non-person felony. The defendant's criminal history score was found to be that of A, as in Adam. That would leave him with a presumption of prison and a presumed range of 15, 16, or 17 months. If he has to do that time, he'll be eligible for up to 20% good time credit and subject to 12 months of post-release supervision. Special rule number 9 applies to this case. That is that this crime was committed while on felony probation. If Mr. Shaffer were to be granted probation today, it would be presumed to be 12 months to community corrections. I would ask you first, Mr. Sokoloff, did you have an opportunity to review the pre-sentence investigation? Any additions, corrections, or challenges?
I have received and reviewed the document, Your Honor, and I have no comment or amendment for the court at this time.
Mr. Russo, same question.
Thank you, Judge. I have reviewed the documents and we have no additions or deletions and no challenges to the criminal history score of A.
All right. And as I recall, the parties were anticipating that that would be the defendant's criminal history. Given that there are no challenges, I will adopt the findings for today's hearing. Mr. Sokoloff, anything else as way of comments as to sentencing?
No, Your Honor, this is not certainly this court's first rodeo. Well, nor quite frankly is it Mr. Shaffer's first rodeo either. Certainly the nature of the charges were such that the state could have attempted to get a lot more out of them. All things considered, we felt this was the appropriate resolution. And for the charge he's facing, our legislature has said that 16 months in KDOC is the appropriate standard sentence, and that's what we would ask for the court to impose here today.
All right. Mr. Russo?
Thank you, Judge. We would also ask that you follow the terms of that plea agreement, which does call for the 16-month standard sentence. He be given all the credit that he has been in and due, and that he would do his time in KDOC.
All right. Mr. Shaffer, now is your opportunity to tell me anything you want me to know in mitigation of your sentence today.
I don't see anything wrong with it except for that I was not on probation when I did catch the discharge.
All right, that's good to know. They had you listed as being on probation in a case called 2014 CR 919, and that was a case of, let's see, that was the one that you had ag robbery, conspiracy to commit ag robbery, and ag burg. Were you not still on probation out of Lawrence at the time that this happened?
No, I was not. I got let off of probation in July.
Okay, in July of what year?
2019.
Okay. And this was alleged to have happened in August of 2019. Miss Ariola, do you know anything about that? Do you have any records there?
Yeah, I'm looking through the records right now.
Right.
Okay. Says he was given 36 months to community corrections on, let's see the sentencing date. I apologize for being slow at this.
You're okay. You didn't anticipate it. That's fine.
It is very possible. If you could give me just a few minutes, I can look in eFlex to see if they
All
have
right.
closed him.
And it doesn't really affect the sentencing that I'm giving him today. So yeah, take your time while I talk with Mr. Shaffer some more here and see if you can locate that information. It
Okay.
sounds like if it was a 2014 case, unless he got extended on that probation for some reason, that it would make sense that it had expired. Even if he did get extended one time, it's
Well,
still.
Your Honor, the conviction date wasn't until March of 16. So I mean, he may be right, but the timing,
Right.
it could be very well close, but the conviction is March of 16. So if sentencing was done in April or May, but it would take a short extension to get him
Sure.
beyond August.
He was sentenced on June 30th of 2016, and it was a 36 month. So, I mean, he very well could have been
Alright.
on, but it barely. So let me look. Let me double check.
Okay, so while you do that, I'll just note for the record that the implications of him being on probation are a couple of things. One, that he would lose a presumption of probation and he would go to no presumption. Well, he's presumptive prison already. And secondly, that I would order this case to run consecutively to the sentence in that case. And if that case is closed, whether or not it was open at the time of the commission of this crime, there's nothing for it to be run consecutive to. So I don't know that it makes a difference. I want this PSI to be accurate in case for some reason it comes forward later that it matters. But as to what sentence Mr. Shaffer receives today, I think the de facto situation is such that application or not of special rule number 9 won't make any difference to this case. Mr. Sokoloff, Mr. Russo, do you agree with that?
I do, Your Honor, and for what you've said, and also for an additional point, which was that clearly the sentence imposed from the Douglas County case was one of probation. If in fact an incarceration sentence was pronounced today, as is contemplated in the plea agreement, you would not run the incarceration consecutive to a probation in another jurisdiction. So I believe it a distinction without a difference. I agree that it should not affect here today.
All right.
And I
Mr.
agree that, yes, Judge, I
Okay.
agree that there is no difference.
All right. Given that, Mr. Russo, do you know any legal reason why I should not now pronounce sentence?
No, Your Honor.
All right. Well, I'm going to follow the plea agreement and the sentencing guidelines in this case, and I'm going to sentence the defendant to a period of 16 months in the Department of Corrections. He'll be eligible for up to 20% good time credit and subject to 12 months of post-release supervision. He is not applying for probation. Probation would not be appropriate in this case, and it is denied. He'll be given jail time credit for every day that he's been in jail on this case. It does not appear that there's anything to run it consecutive to. As far as costs and fees, I think there's nothing preventing Mr. Shaffer from working once he is released. In fact, I'm sure that will be part of his post-release supervision. So I'm going to assess the court fees against him. There is no supervision fee since he's not being granted probation. He has retained counsel, and his DNA should already be on file from old convictions. So I don't think there's anything other than the court docket fees to assess. I think once he gets out and gets on his feet, he should be able to pay $50 a month towards that. Mr. Shaffer, once you're out, you plan on getting a job and being able to pay $50 a month for about 4 months or so until this is paid off?
Yes.
All right, that'll work. All right. Mr. Shaffer, I have to advise you that you have 14 days from today to appeal anything you don't like about your sentence. You also may be able to seek expungement after a period of time following successful completion of supervision. As a convicted felon, it's prohibited for you to own or possess a firearm, certain kind of deadly cutting instruments like dirks, daggers, switchblades, basically knives that could be considered deadly weapons. You understand all that?
Yes.
All right. Mr. Sokoloff, things that I forgot to cover today.
I think we got everything, Your Honor, for the court's edification. This is not a case where we would ask for restitution as the property was recovered. So I have nothing else for the court.
Mr. Russo?
I've got nothing, Judge.
All right. Then yes.
It does look like he was released from supervision in July 12th of 2019. Released due to probation expired and defendant having failed to satisfy the terms and conditions of probation, court costs and other fees, fines. $235 were still owed.
All right. I'm going to order that the PSI be amended and the reference to special rule number 9 be stricken.
Okay.
All right. Anything else for our record?
Not from the state. Thank you, Your Honor.
Not by the defendant.
We are adjourned. Thank you, everyone. Good luck to you, Mr. Schaefer.
All right.
Thank you,
Thank you.